I now wish to make a few remarks with respect to procedure.
We wish to remind that pursuant to the agreement, the extraordinary chambers exercised and once created, the ECCC issued their internal rules. The internal rules has the object of consolidating applicable Cambodian procedure that is applicable before this court. The agreement provides, as well as the law on ECCC provides, that reference may be made to extra rules when the rules in effect do not deal with a specific question, or in case of uncertainty regarding their interpretation, or if the question is raised regarding their compatibility with international standards. But the internal rules is very clear on this point. Cambodian law before the trial chamber and international rules of procedure may also be used as a reference in case of need. In the context of the difficulty presented by the issue, the preliminary objection raised by the accused, there is nothing to challenge because Rule 89 is perfectly clear. All questions regarding the Chamber's jurisdiction are considered and all these preliminary objections had to be, under the penalty of inadmissibility, be presented at the latest within 30 days following the date when the closing order became definite. The accused and his counsel did not use this possibility. Thus, we say in French, it was too late. When the initial hearing took place, the accused made a few observations, and these observations never focused on the Chamber's jurisdiction, and it is only when this trial began, which lasted 9 months, that the defense suddenly raised this issue and argued on this problem in order to try to demonstrate that from the beginning the chamber did not have the jurisdiction to try the accused because he was not a senior leader, and challenged that he was one of those most responsible for the crimes committed. The chamber considered that this late submission could not constitute a regular preliminary objection. In the same way, the defense's arguments, according to which, pursuant to Annex 5 of the 1981 Paris Agreement and of the law outlawing the members of Democratic Kampuchea from 1994, that the accused could not be prosecuted for the crimes charged. And these arguments were also presented in a belated fashion, and thus were also rejected. And we would like to remind as well that during the first substantive hearing of 30 March 2009, a full reading was given by the co-prosecutors of the indictment, and Duke, who was present during this hearing with his counsel, point by point accepted the vast majority of the charges despite their gravity, and did not and only challenged a few details that seems maybe secondary, or let's say very limited in relation to all of the charges. But pursuant to Rule 87 of the internal rules, subparagraph 6, it is expressly provided that when the co-prosecutors and the accused agree that there is nothing to challenge in the indictment, that the chamber can consider that these facts are proven. That is to say that following this first day of hearings, following this full reading of the indictment, following this acknowledgement to more than 80% of the facts in this indictment, well, the chamber established the evidence that proved the facts in a proper manner. So in this context, the accused and his counsel never challenged that the ECCC had jurisdiction vis-à-vis him, nor that he was part of those most responsible for the crimes that were committed under Democratic Kampuchea due to the facts that are charged. Thus, the lack of jurisdiction of the chamber was neither raised formally nor in a regular manner by the accused in regard to the internal rules. or in limine litis, and this is thus pursuant to Cambodian rule and pursuant to international humanitarian custom law to which Cambodia abides, that the Chamber deemed that it was seized on a regular basis and considered that the facts held against Duch proved the personal jurisdiction of the court and thus allowed the court to sentence him. Thus, and in the interest of the civil parties, we kindly are requesting you to confirm the judgment that was handed down by the trial chamber on 26 July 2010 in the fact that it re-examined the terms of its personal jurisdiction and retained Duke as being part of the category of the suspects and whose judgment falls under the agreement as well as the ECCC law. And it is in this context that we will confirm that Duke falls indeed under the personal jurisdiction of the court. Thank you.
The President, Defense Counsel may reply, should they wish to do so. I mean, they reply both to the co-prosecutors and the civil party lawyers. Counsel, thank you, Mr. President. I would like to reply to the response made by the co-prosecutors. First, the prosecutors indicated that Doche acknowledged the crimes committed at S-21, and that such acknowledgement proves that Doche falls under the personal jurisdiction of the ECCC. Allow me to emphasize that Doche acknowledged the crimes committed at S-21 even when he was before the military court. He did not contest it. But the question here is, who is the main author of the crimes? It was those people who had the right to make the decisions and orders, and that Doche did not enjoy such right. He received orders from Sun Sen and Nuon Chea. Point number 2, the co-prosecutors indicated that the Defense Counsel raised the matter of preliminary objection, which is contradictory to the facts and the law at issue. Allow me to respond that judgment paragraphs 15 and 14 indicated that clearly that the matter raised then was not the issue of preliminary objection. In short, third, the co-prosecutor said that Doche falls under the jurisdiction, personal jurisdiction of the ECCC, while the Defense Counsel challenged. I would like to draw your attention to Penal Code Article 24, which indicates that each individual shall be liable for his own crime. And these crimes were not committed by the accused himself. In the final submission of the co-prosecutors, paragraphs 15 and 11 and 10 of the indictment or closing order indicated further that the Communist Party of Cambodia issued the orders, not Doche himself. So those who issued orders must or shall be accountable for the crimes. While Doche only received order, he shall not be liable for the crimes. Number 4, the prosecutors indicated that the lawyer, the defense counsel, failed to request that the co-investigating judges summoned Nuon Chea for questioning. I would like to show this piece of evidence that Mark Salomon, the co-investigating judge, and Mrs. Anna Austin advised or ordered the judicial police, Mr. Beston, to only investigate inculpatory evidence and that not exculpatory evidence. Of course, this task must be vested with the co-investigating judges to do so, but they failed to do it. Deutsche was not really the senior person. Even his superior was not really holding the highest position. On top of him, there were more than 7 people. When Son Sen went to the battlefield, Nuon Chea was Son Sen's successor, and Nuon Chea was already stated in Deutsche's testimony that he was the chairman or the superior of Deutsche. And Nuon Chea himself was not summoned to the hearing. So why should this be the role or the task of the defense counsel to do so? Why not the task of the judges? Point number 5. Everyone is quite familiar already that the democratic Cambodia is a lawless regime. Since the regime is lawless, whatever any individual did was not against the law. How could it be against the law if there was no such law? Number 6. The prosecutor indicated that the defense counsel referred to the law on the outlawing of the Khmer Rouge group. I would like to make it clear that we did not really make such assertion. We only refer to the ECC law. The co-prosecutors are those who really protect the law, not the defense counsel. Defense counsel are those who enforce the law or implement the law. The Article 129 of the law states that the proceedings, the trial proceeding must be in accordance with the existing law. And the law outlawing the Khmer Rouge is still in force, and we would like to appeal to the co-prosecutor not to violate the Constitution, Article 129. 7. The prosecutor indicated that S21 Security Center was the central security center, while Chong Chroy Security Center was very small at the district level. But I would like to draw the Supreme Court chamber attention regarding how many people killed in that Chong Chroy Security Center. You call it a small security center where more than a lot of people were killed. More people even were killed at Chong Chroy than at S21. Why such a security center and chief of that security center did not fall within under the jurisdiction of the ECC? And the law really requires that individuals are liable for the crimes they have committed, because there are mens rea and actus rea, and that the institution was supreme. The law states that only the senior leaders and those who fall under the personal jurisdiction of the court shall be prosecuted, and that the chiefs of security center of Chong Chroy and S21 were not those who shall be prosecuted under the personal jurisdiction of this ECCC. Point number 8, the prosecutors indicated that the defense counsel during the trial proceeding indicated that we did not challenge the jurisdiction of the ECCC. Now, I would like to make it clear that we are not challenging the jurisdiction of the ECCC. Again, loud and clear, because the ECC has jurisdiction to bring to justice those senior leaders and those who were most responsible for the crimes committed during that regime. But what we are challenging is the methods employed by the prosecutors before the trial chamber to put Deutsche as or presume that Deutsche was the senior, the most person responsible for the crimes for the purpose of these trials. Point number 9. The co-prosecutors indicated that they have the right, according to Article 40 of the Penal Code. Of course, I fully concur with them that this right should be well enjoyed by the prosecutors. But here at this tribunal, Article 5, subparagraph 3, and Article 6, subparagraph C of the agreement of the ECCC set the scope of investigation and the prosecution to be maneuvered by co-investigating judges and prosecutors. So this scope has been well set. It doesn't mean that co-prosecutors or investigating judges can do whatever they wish. Otherwise, it cannot be accepted. They have to really exercise their power within the confined and limit the set rule. In relation to the civil party, who indicated that during that time there was no law, but I think they did not really fully cite our submission. I did say further that at that time there was only political line, only the policy by the ANCA that no one could not contest. Who could contest such policy or line? For example, Deutsch was at S21 when Wonwit, who was his former superior, was sent in. That person had to be smashed. Deutsch himself could not intervene because the regime already said so, that the person had to be smashed. The line did direct everyone to really follow it. And I think that is all from me. I would like to share the floor with my co-counsel. Mr. Kong Ratiri, thank you, Mr. President, for allowing me the floor to add further on top of what my colleague has just indicated. The co-prosecutors used a lot of terms in relation to the charges brought against Kang Kek Eo, alias Deutsch, and that Deutsch falls under the jurisdiction under this ECC by its discretion. The use of discretion without any reference to the facts or evidence or standard constitutes to a violation to Article 13 of Geneva Convention of the 12th of August 1949 in relation to the right, civil and political right when it comes to due process. Article of the Criminal Procedural Code of Cambodia, which prohibits strongly the interpretation of the laws by means of analogy. So any application of jurisprudence by international tribunals are erroneous, and that the Defense Counsel requests that such assertion be rejected. Regarding the internal smash, the defense support the idea that it is true, and because the function of smashing the internal people or people in the party rank means that only people who were in the rank would be affected, not other victims. And S21 was tasked with smashing the enemy of the state. Anyone who would like to challenge the party would be smashed. So other than that, there are only about 5 to 10% of the people who were innocent prisoners. Among the many prisons, I would like to only raise 9 prisons where more people were executed. For example, like at one prison, 10 times the number of prisoners were executed. At, for example, Chong Chroy, more than 100,000 prisoners were killed. Prison Po Tun Le in Kandal, 350,000. Wat O Tra Kuon, Kampong Cham, more than 320,000. Wat Kampong Tra Laj, Kampot, more than 210,000 people. Wat Takau, Bati, and Wat Barai, Kampong Thum, more than 100,000. Takau, Borai Julasa, more than 150,000 to 200,000 people were killed. But at S21 or Tuol Slang in Phnom Penh, Dong Kao, only 1,400 people to 150 people were killed. And those who were killed at S21 were only soldiers who were perceived as enemies of the state. And there were 2 main groups of people who were killed, the enemy of the Angka and the enemies of class. Civilians, I mean, who were accused as enemy. They were former officials or capitalists or feudalists, and in particular the 17th April people, as they call it. S21 had scope over the whole country, but individual scope was limited. And the other prisons that I mentioned had bigger scope of coverage than S21 when it comes to the broad term. The prosecutor indicated that they maintain their discretion to interpret how to define people under the jurisdiction. And however, they fail to refer to any law in relation to this particular assertion. Among the many senior leaders of the Khmer Rouge, some people were not involved in the crimes, and this assertion can be found in the preamble of the report presented to the General Assembly of the United Nations. And only those who were responsible for the crimes were regarded as senior leaders. So the people who committed the crimes, and I think the prosecutor have made a mistake in defining these terms. That's why it has given rise to the full submission of documents before or evidence before the court. The ECCC determination on the personal jurisdiction does not heavily rely on just the evidence submitted by the court prosecutors. They, at the same time, need to look at the personal jurisdiction and the jurisdiction over the offences, because the chamber is vested with the power to review these on its own. For example,
Hai
to
ការ
which
លើកឡើង
group
របស់
of
សហមេ
people
ធាវី
shall be
ថាជា
prosecuted
ការលើកឡើងយឺត
and
ពេល
to
គឺ
which
ជារឿងមិន
group
អាច
shall
ទទួលយក
not.
បានទេសូមទាត់ចោលពីព្រោះថា
And
ការ
the
លើកឡើង
defense
របស់
would like
សេច
to
ក្តីសន្និដ្ឋាន
challenge
របស់សហមេធាវីការពារជនជាប់ចោត
the assertion by the prosecutor regarding this, and that when it
អញ្ចឹង
comes
ចង់បញ្ចប់និសាវនាការទើបឲ្យគាត់ធ្វើសេចក្តីសន្និដ្ឋាន
our
ពេលនោះ
submission
គាត់តាំងបានលើកឡើង
concerning
ដែរ
the preliminary
គាត់តាំងបន្ទុកទៅលើ
objection, because we had to really submit this submission rather late in the proceedings, because more evidence had been located, and that our assertion or arguments have to refer to the evidence according to Rule 87 of the internal rule, because the rule states that evidence can be submitted by the parties at any time during the proceeding, and that reference to Rule 89 to reject Rule 87 is not proper. I would like to admit that S21 was the central prison, and Deutsche never contest such assertion, because he believed, he was convinced that this prison was the prison of the center and the military prison. It used to be under the supervision of Division 703, who was chaired by In-Lon alias Nat, who ended up being the victim of S21. Because the prison was the central prison, that's why central people were overseeing this. For example, they have the people from the party's line and the government line, people including Pong and Lin, who oversaw another prison at Wat Butum. At Wat Butum was the place where people who challenged Pol Pot personally directly were kept and smashed. And from the border party's line, for example, there was Pong and members from the standing committee. And from the government, there were a committee of the central military. And I think the information has already been indicated in the case file, and also the general staff of the army, which was chaired by Son Sen. There were a lot of divisions and division commanders, including Mihmut, Sumed and other people. Son Sen really oversaw directly this prison, and when Nuon Chia succeeded Son Sen, Nuon Chia exercised the power to control S21. We agree that for prosecutors, it's 50% correct when they indicated that S21 was a central military central prison. Other prisons. We agree with the co-prosecutors that those prisons at the zone were independent, and that their function was lower. But I think we challenge such assertion, because at S21, the head of S21 could not really interfere in the affair of other prisons. When report was made from zones, prisons, they were sent directly to Pol Pot, not to S21. That's why Pol Pot ordered such arrest, and that ordered Son Sen to arrest those people. We noted that that's why some prisoners were brought in from the zones. Deutsch indicated that he never received any prisoner from the west, the southwest zone, because Tamok was the head of that zone, secretary of that zone, and he was in control of the prison there. And you may also be familiar with the southwest zone, the chairman of which was very cruel. And the prosecutors also submitted evidence concerning the secret decision by the DK of 30th of March 1976. We are not suspicious in relation to who are bound by Articles 1 and 2 of the ECC law. I would like to end this submission regarding the prosecutor's response. I would like now to proceed to the reply
សូម
to
ទាត់ចោល
the
ទាំងសង
civil
ចំពោះ
party
សេចក្តីសន្និ
lawyers.
ដ្ឋានរបស់ដើមមិនដឹងរដ្ឋប្រវេណីពីព្រោះវាប្រឆាំង
I
ទៅនឹងមា
completely
ត្រា 2 នៃ
reject
ក្រមនីតិ
the
វិធីព្រំប្រទាន
assertions
កម្ពុជា
by the Civil Parties
ត្រង់ចំណុច
Council.
ទីត្រង់កថាខណ្ឌ3
This
បាទ
is contradictory to the
បណ្ដឹង
ECC
អាជ្ញា
law
និងបណ្ដឹងរដ្ឋ
in
ប្រវេណី
paragraph
ជាបណ្ដឹងពីរផ្សេងពីគ្នា
because
បណ្
civil
ដឹងអាជ្ញា
action
មានគោលបំណង
and
និង
criminal
ពិនិត្យអ
actions
តិភិប
are
នៃ
two
បទល្មើស
separate
បង្ហាញឲ្យ
actions.
ឃើញប្រវត្តិភាពនៃជនល្មើសនិង
The
ក្រុម
criminal
ជាទោសជន
action
នេះ
is
តាម
to
ច្បាប់កំ
find
ណ
the
ត់
guilt
បណ្ដឹងរដ្ឋ
of
ប្រវេ
the
ណីមាន
accused
គោលបំ
and
ណង
to
ធ្វើឲ្យ
punish
ជួសជុលការខូច
accordingly.
ខាតដែល
And
បណ្ដាលមកពី
the civil
អំពើ
action
ល្មើសដល់
is
ភាគីរងគ្រោះហើយ
to
ក្នុងគោល
find
ដ
the
ងនេះ
harms
ឲ្យអ្នក
committed
រងគ្រោះបាន
upon the
ទទួលសំណ
person
ង
or the
ជំនឿចិត្ត
victims
ធួនល្ម
and
ម
to
និង
seek
ចេស្តកម្មទទួលបានទទួល
reparations
បានន័យថាគាត់ធ្វើបាប
proportionate to the
ធ្វើសេចក្តី
harms
សន្និ
they
ដ្ឋានឆ្លើយតប
suffered.
មកឬក៏ដឹងទៀមទាបានតែលើសំណងរដ្ឋប្រវេណីទេ
It means the
តែ
civil
បណ្ដឹង
party
អាជ្ញាត្រូវធ្វើ
lawyers
ឡើង
could
ដោយ
only
ថាវិ
seek
ញ្ញាដូច្នេះ
reparation
ខ្ញុំមិនអាច
for
ទទួលយក
the
បានរាល់សេចក្តីសន្និ
civil
ដ្ឋាន
part
សូ
of
ម្បី
the
តែមួយម៉ាត់
judgment. So whatever the assertions are, I completely reject it.
ថា
Only
លើ
the
បញ្ហាថាការងារកិច្ចហត្ថបិកហ្នឹងមាន
make
ស្ថិតក្នុង
assertions
យុទ្ធ
on the
យុត្ថាធិការរបស់
criminal
អវតក
actions.
អត់មិនមែនជាភារកិច្ចរបស់អង្គ
So
លោក
this
ទេ
is not the
បាទសូមអរគុណសូម
obligation
ចាប់
of
ត្រឹមប៉ុណ្ណេះ
the lawyers for the civil parties to assert on the issue of personal jurisdiction of my client Dutch.
ចឹងនេះពេលថ្ងៃនេះគឺយើងបញ្ចប់
The President,
ដល់
it is now time appropriate for the adjournment for today.
ការពារជនជាប់ចោតចឹងអង្គជំនុំជម្រះគណៈការពូប្រកាស
And the court will adjourn
នាពេលនេះហើយបន្តនៅថ្ងៃស្អែក
and will resume tomorrow morning, the
នៅវេ
29th
លាម៉ោង9ព្រឹក
at 9 a.m.
គាត់ឲ្យមន្ត្រីពន្ធនាគារ
Security guard, Tribunal instructed to
នឹងបង្គាប់ឲ្យនាំ
bring the accused back to the detention center and bring him back tomorrow morning
2011នៅវេលាម៉ោង9ព្រឹក
at 9 a.m. The court is now adjourned.
សូមជើញក្រោកឈរ
The graphic all rise.